All right, let's talk about something we do every single day. Use apps and websites. But have you ever stopped to think about the journey your personal data takes? With India's new Digital Personal Data Protection Act of 2023, that whole journey now has a brand new legal map. And for companies, that means a whole new set of responsibilities. So what are they exactly?
Okay, but before we dive in, the usual quick and important note. This is all for educational purposes. It's not professional legal advice, and of course, laws can change. So please always consult a professional before you take any action.
You know the drill. You download a new app, a box pops up, you scroll, or let's be honest, maybe you don't, and you just click, I agree. We've all done it, probably 1,000 times. But what really happens after that click? What are you actually authorizing? And what legal duties does that put on the company that now has your info? That's the big question we're going to unpack today. All right, so to really get the rules of this new game, we first need to know who the players are. The DPDP Act basically lays out 3 key roles that define this whole relationship between you and the companies handling your data.
First up, and honestly the most important player on the field, the data principal. The law is super clear on this. This is the individual the data is all about. So for the rest of this chat, anytime you hear data principal, just think, hey, that's me. It's you.
So, what's considered your personal data? Well, the Act defines it really broadly. It's not just the obvious stuff, like your name or phone number. No, it's any piece of data that can be used to identify you either by itself or when combined with other info. We're talking location data, your online habits, what you buy. It's a very wide net.
And that brings us to the data fiduciary. Now, this is the official legal term for the company, the app, the organization that gets to decide why and how your personal data is going to be processed. The easiest way to think about them? They're your data's legal caretaker. You've entrusted them with your information, and with that trust, well, it comes with a lot of responsibility.
And you know, the single biggest responsibility, the very foundation of this entire law, is how that caretaker asks for your permission in the first place. This brings us to the most important concept of all, consent.
So the days of bearing consent in 50 pages of tiny legal text, yeah, those are over. Under Section 6 of the Act, for consent to actually be valid in the eyes of the law, it has to check all these boxes. It must be freely given, not forced. It has to be specific, for the exact reason they need it. You have to be informed about what you're agreeing to, and it has to be a clear, positive action, like you actually ticking a box. No more pre-ticked boxes are assuming that if you don't say no, it means yes.
The Act itself gives some really good examples to make this crystal clear. Let's say you download a telemedicine app. Okay, it obviously needs some of your data to give you medical services, right? But does it need access to your entire phone contact list? The law says absolutely not. So even if you clicked agree to everything, your consent is only legally valid for the data that's actually necessary for that service.
Here's another great example of what companies are not allowed to do anymore. Imagine you're buying an insurance policy. The company can, of course, ask for your consent to process your data to give you that policy. That's totally valid. But what they can't do is bundle that with a clause that makes you give up your right to file a legal complaint. That part of the agreement, it's invalid from the second you see it.
And this is a huge one. Consent isn't a one-and-done deal. Section 6, subsection 4, gives you the power. You have the right to withdraw your consent at any time you want. And the law says it has to be just as easy to take it back as it was to give it in the first place.
Okay, so the company is asked the right way, and you've given them valid consent. The data journey continues. So what's next? Well, now we look at the caretaker's main job, protecting what you've given them.
This is a core command from the Act. The data fiduciary must put reasonable security safeguards in place. We're talking things like encryption, access controls, all to prevent your data from being breached. This isn't just a nice-to-have. It's a fundamental obligation to protect the data they hold, no matter where it is.
But what happens if those safeguards fail and there is a breach? The law is very, very clear here. The company has 2 immediate, non-negotiable duties. First, they have to inform the new Data Protection Board of India. And second, just as important, they have to inform you, the person whose data was actually affected.
And it's not just about security. The Act lists other general obligations too. Companies have to make sure the data they have about you is accurate and up to date, especially if they're using it to make decisions that affect you. They also have to be accessible. Publish contact info for a grievance officer and have a real working system in place to handle your complaints. Now, the law is smart. It recognizes that not all data is created equal and not all data caretakers are the same size. So in certain situations, the rules get even tougher, imposing what are called special obligations. Let's take a look.
First and foremost, the Act puts a much, much higher wall of protection around the data of children. And in this law, a child is anyone under the age of 18.
Yeah, Section 9 is incredibly specific about this. Companies are straight up forbidden from tracking children, monitoring their behavior, or aiming targeted ads at them. And maybe most importantly, before processing any of a child's personal data, they have to get verifiable consent from a parent or a legal guardian. The burden of proof is totally on the company to get that right.
The law also creates this special category for the really big players, the large-scale data handlers. They're called significant data fiduciaries. The government will actually designate who fits into this category based on things like the sheer volume and sensitivity of the day-to-day process and the potential risk to all of us. You know, think of the major social media platforms, the big tech companies. That's who we're talking about. And because of their massive size and impact, these significant players have extra homework. They have to appoint a data protection officer who's based in India. They have to hire an independent data auditor, and they have to conduct regular data protection impact assessments, which are basically these formal reviews to find and fix any risks to our data.
All right, every journey has to have an end, right? Your data's journey is no different. And this is one of the most important new obligations for companies, knowing when it's time to let your data go.
This is a huge shift. Under Section 8, companies can't just hoard your data forever. The rule is actually pretty simple. Once the specific purpose for which you gave them your data is done, they have a legal duty to erase it. The same thing happens if you withdraw your consent. That whole let's just keep it just in case era, it's over.
And again, the Act gives a super simple example. You use an online marketplace to sell your old car, and you give them your data for that exact purpose. The second that car is sold, guess what? That purpose is fulfilled. The marketplace then must delete your personal data. It's a clear beginning, a middle, and an end to your data's journey.
So what was once this kind of fuzzy, often one-way street for our data now has clear signposts, rules of the road, and a final destination. This law gives the journey a legal beginning with informed consent, a protected middle with duties of care, and a definitive end with the obligation to erase. The big takeaway is that the power is shifting. So the next time your cursor is hovering over that I agree button, maybe you'll think a little differently about the journey you're about to authorize.